So I speak a lot at, universities, and I speak at tech companies, and I always ask the same question when I speak. And I'm going to ask you it, and you can answer it at home. But I always ask, what percentage of parents here in California have an estate plan, like a will and trust? What percentage do you think? And usually most people shout out like 20%, 10%. There's always that one parent who's like, no more than 1%. They have no faith in us fellow Californians. But the reality is, if you live in California and you are a parent, 100% of you have an estate plan. And it's confusing, right? And the reason is, if you have not done planning to protect your children if you should get hurt or pass away, California has a default plan, and they've already done it for you. And so I want to fill you in on what that looks like, and then tell you things that you can do to proactively change it, so you could set everything up the way that you would want, in a way that would be best for your kids. So the first area that we always start with is, what does happen to your kids if something happens to you? Hopefully you have a surviving spouse that could be there to care for them, but things happen, people are divorced, or parents both pass away, whatever the situation is. And so what most people don't realize, that if you don't name permanent guardians, meaning fill out the correct legal paperwork designating someone to raise your kids, that a judge who doesn't even know you would have to choose a guardian for your children. And that is a long court process. It's heartbreaking. It's something we would never want our children or our parents, anybody, to have to be part of if something should happen to a parent. And so all you need to do to remedy that is, you do need to complete a legal document, and sending your sister an email or putting it online or telling someone, it's not enough. You actually need to complete the appropriate legal paperwork naming guardians for your kids to raise them if you cannot. And so a couple things to keep in mind on that, because it's not just as simple as just filling out a name. You're really going to want to do a first choice of who you want, a second choice, and a third choice. And the reason being, if for some reason your first choice passes away with you or can't do it, that we want to make sure that the next in line has already been designated and can assume that role. So you're going to want to make sure you have three choices. If you are naming couples like your brother and your sister-in-law, you're going to want to specify, if you want them together, are you okay if one of them can't do it? Are you okay if, they divorce? What do you want to see happen in that situation? Or what if they, one of them predeceased you? So you do want to kind of address that scenario as well. And then parents usually at this point, they're like, gosh, I'm not sure who to pick. What about if my brother doesn't end up getting married, or, whatever the scenario? And so one of the tricks I teach parents, and I really want you to do, and it takes a lot of the pressure off of having to predict the future, is just name who you think is best for the next 3 years. You can always revisit the document, assuming nothing happens to you, of course, but you can always revisit it. And guardians do change. We always joke that after the holidays, everybody's changing their guardians, right, from their family members. But guardians change, kids grow up, they form new relationships, and what worked a few years ago might not work now. And so we really want you to think about that when you're filling out your form, just to kind of commit to the next 3 years. The other piece that gets overlooked even by a lot of estate planning attorneys is what happens in the short term. Because obviously you can fill out the paperwork, but someone would have to find it. If you have little kids, how is somebody going to know who the permanent guardian is? And what happens in that situation? So unfortunately, there is the scenario that nobody knows who's supposed to be raising the kids. They haven't found the will, and kids could get placed into temporary foster care. That would be the extreme. It's not what temporary foster care, it's not what CPS would want. They want to know who you would want. And so really what you want to do is you need to name not just a permanent guardian like we just talked about of the long term to raise your kids, but you really want to identify maybe 4 to 5 family members or friends in the immediate area where you live, so that they can temporarily keep your children in an emergency. And along with that, I really want you to think about completing a medical directive for your kids. So that way, who you want and who you trust can make decisions for your kids in an emergency if you could not. And so all of this type of planning, we recommend that you do, really focusing on your kids. It's really thinking about who would raise them long-term, who could be there in the short term, could their medical decisions be made, and then also like a roadmap to their life. Where do they go to school? What organizations are important to you? All of that needs to be properly documented and properly captured. Down to, I know I have this myself, and I certainly have my clients do it, but you really need emergency cards in your wallet, the old school form, right? Where it's the hard copy. It's not just stuck in your phone that may or may not have a password, but you really need to have those temporary caregivers that you've, chosen. You need to have them listed in your wallet so first responders would even know who to call. So the next thing that I want to really help you think about is, what about your house, your money? Everyone's like, oh, who gets my student loans, right? That too, right? So what about all of that? What about your assets? How does that go from you to somebody that you would want to get them? And obviously, if you're married and you pass away and everything was just held jointly, it would automatically pass to the other joint account holder. But I will tell you, even for married couples, most of the time that's not the case. There's usually a brokerage account that was just in the husband's name or the wife's name, or maybe someone didn't make it on their home title. Sometimes parents don't even know, are they both on a deed? And they're not even sure. And so that's how the chaos begins when even one parent passes away. And then certainly if both parents passed away, then you're truly in a situation where your family would have to go through a very long and expensive court process called probate. If you think going to traffic court is a pain, you don't even want to know what probate is like. It is awful. It is at a minimum in California, especially here in Orange County, at a minimum 18 to 24 months long. It's open and public, so everyone in the world can see what you have. They could know everything about you. And it's full of lawyers. Nobody wants to have to talk to a lawyer. I am a lawyer, I understand. Nobody wants to have to go, spend 2 years with an attorney in a courtroom. It's very time consuming and it's very, very expensive. It is so expensive in California. So I can get you the charts, but it basically, and you can Google it, but it basically starts out where it will cost you 8% of your estate worth. And as your value of your estate goes up, it'll slide down percentage wise. I see probates all the time here in California and Orange County because of the high home prices, especially. I see probates that cost several tens of thousands of dollars, if not more. And that is the norm. And so it's something where not only is your family losing you and getting stuck in this awful court process, but all that money that could have gone to your kids is instead going to the government. And that really is California's default plan. So as difficult as they make probate, what's so great is they make it so easy to avoid it. And so all you need to do to avoid probate is you need to set up what's called a revocable living trust. A lot of people growing up, we heard the term trust and we thought of like really wealthy families, right? Or richy rich. But really a trust is for everybody in California pretty much, because most of us would be subject to probate. So what a trust is it's basically a legal document that your lawyer will help you prepare, and it says, this is who I am, this is who I love, these are my children, this is how I want the money to go to my spouse, and this is how I want the money to go to my children. And when you set up that trust, what's so great is as long as your attorney, is helping you and you connect all of your assets like your home and your bank accounts to the trust, then you're not even having to go through probate. You're completely opted out and you did everything privately in advance. And what's really nice too is you're not subject to probate's default rules where your kids would just get everything outright when they're 18. That happens. Instead, in your trust, you would say at what ages you think they're old enough to be controlling their own money, and you designate someone, maybe a grandparent, an aunt, or an uncle, who would help manage the money for them and give them what they need until they come of that age that you think is right. You can also get pretty sophisticated with the trust where if you want to make sure the money would be protected from your spouse's future marriage if you were no longer there, or if they're a business owner worried about lawsuits. Same with your children. If you want to protect their money from their future marriages or creditors or predators or lawsuits, you can get really sophisticated within the trust and you can set it up with asset protection. So it'd always be there for your family and who you want, but it's protected from the outside world. So So many great options. One more I want to mention, because 1 out of 69 kids here in Orange County have autism. And so we do have special needs issues that our families are dealing with. And so it is critical, if you have a child who has a special need, it is critical that you make sure your trust is structured as such where the money you leave behind would go to them through a special needs trust. And that's something, when you do look for an attorney, you want to make sure they're not just an estate planning attorney, but they also do special needs planning, which is a niche within estate planning. So those are some things to think about, but you can avoid that long and expensive court process of probate by simply setting up a trust while you're living, and it's something we really want to encourage you to do. The next thing that we want to put on your radar is estate taxes. And so right now the exemption's super high, meaning you can have, for an individual, a little over $11 million and pass it to whoever you want without them having to pay estate taxes. So if you have an estate tax problem, congratulations, you can share it with the rest of us, right? But if you have an estate tax problem, there are a lot of sophisticated techniques that your attorney should be able to help you do to mitigate those taxes. And a lot of that is done through charitable giving. But I want to make a quick pitch. Whether you have an estate tax problem or not, incorporating charitable planning to your family estate plan, it's beautiful. It's a wonderful thing. It's a great way to carry on your legacy. So it is something that when you look at setting up your trust that you really want to think about. The next thing I want to think about with you is your medical directives. And so I can tell you a story. I knew someone very dearly who called me and said, "Did you hear what happened?" And that's a terrible way for a phone call to start. She went on to tell me that her husband had been seriously injured in a traffic accident, and she had a young child at the time. And I learned in that moment of listening to her in her shock, when she said, "The doctors are saying that I need to think about removing him from life support." I learned in that moment, it's shocking. She couldn't believe it. And she wasn't processing things, of course, the way that we would in the hypothetical. And I learned how critical it is that you have medical directives so that if, God forbid, you find yourself in that situation, you have made your wishes known. Your spouse doesn't have to guess. Your spouse doesn't need to get pressured from other family members. Or if you're not married, your family members don't have to try and guess what your wishes were. You need to make it clear. And then you're going to want to designate someone you trust to be able to make those decisions if you can't make them yourself. So please make sure that you complete your medical directives and make sure they're accessible. So many times people complete them, but they're not really helpful, so nobody knows where they are. And so one of the things I really think that I want to encourage you to do is make sure that you file them with your local doctor. Make sure you file them with your local hospital, and make sure whoever you've chosen to be in charge of your medical knows exactly where those documents are. The last thing I want you to think about as a parent, which is really hard, is the fact that if you are no longer there, that's obviously a terrible, terrible void for your child. Very, very sad. And I hope, I'm not a psychic, I hope we all live right until we're 90, and statistically, right, we probably will. But if for some reason tomorrow didn't come, make sure that you've taken time to preserve the most important asset for your child, and that is you. One of the things that we encourage you to do, and you could do it right now with your iPhone when you're at home, but take time to tell your family that you love them. Preserve special memories. I will tell you, we had a situation where someone had set up their planning and their hypothetical. This parent was totally fine. They later found out they were going to pass away. And one of the things that this parent did was they completed a legacy interview that we do with our clients, where they answer important questions about their lives so it's preserved for their children. And where we happened to check the audio on, this parent was talking in depth about each of this parent's children and talking about what was special about them and what this parent saw in them and their strengths. And it's an incredible gift to think that although they no longer have their parent, and this cannot in any way replace that or minimize that, they do have at least that piece in their parents' voice left behind. And so that's something, it's not fun to think about, but it's so important. And you know, just yourself, if you didn't have your loved one tomorrow, you know that's the first thing that you would want. So recap now of kind of the things that we talked about that you need to know as a parent. But right now, if you have not taken the time to formalize your wishes or set up a will and a trust and all of these things we talked about, right now, your kids are at risk of being placed in temporary foster care if something happens to you. Your kids would have to go through a very long open court process for a judge who doesn't even know them to choose who raises them. Your money would have to go through a very long and expensive court process called probate. And then all the money left behind would go outright to your kids at 18 without restrictions. State taxes we're not so worried about, but medical directives, right now, without doing that, you're leaving it to chance of what your family would do. And then plus, your loved ones wouldn't even be able to talk to the hospital because your information is private. And so imagine the stress of that they would feel. And then lastly, you have to take time to preserve yourself for your child. So right now, without any of those things, that is where you are at. And I don't want to worry you or stress you out. But when you take time to set up a family estate plan, you can make sure that your kids would never be in the care of strangers if something happened to you. You could make sure that who you want would raise your kids rather than leaving it to a judge. You can make sure that the money would go immediately and on your terms to your family members and not get tied up in probate court or go outright to your kids at 18 when they're just not old enough to be able to manage it. You can make sure that you've maximized any tax savings, not just estate, but capital gains, all of those things. You can make sure you take care of that. And you can make sure that your medical wishes are known and would be followed. And then you could also make sure that you have said exactly what you would want your family to remember if you are not there. So you have the power to change everything. And I want to encourage you to do that. Now, most of the times when I watch a video, this is where somebody makes a sales pitch. Like, okay, now it's time to buy that neck pillow after telling you about neck pain, right? And I'm a sucker for that. I bought a neck pillow off Instagram too. The only pitch I'm going to make is the one on behalf of your kids. Our kids are at the mercy of our decisions as parents. And I want to make the pitch for your kids for you to get this done. And I want to express my confidence to you, parent to parent, that I know that you can do it. I know it's tough. I know you have other priorities. Believe me, I put off a cavity last year and guess what? I just had to get a crown. Not fun, right? These things are dealing with our children's well-being. We can't put them off. There is nothing more important than us stepping up as parents and saying, I've done this for my kids. That's the only pitch. If, two things that people usually ask me is, one, who would help you set up this planning? And two, what should it cost? So who sets up this planning for you is if you would be subject to probate, meaning you do have assets over $150,000, like you own a home or you have a brokerage account or retirement, you really need to work with a reputable estate planning attorney to do that. An estate planning attorney is not a family law attorney. Oftentimes people confuse them. Family law is if you're getting divorced, so if that's the case, tell your wife you're sorry and see if you can fix it tonight. But an estate attorney is who you need to talk to set up an estate plan that will have a will, a trust, a medical directive, powers of attorneys, all those important things. So one of the things I recommend is you could definitely go on Yelp and get independent reviews of estate planning attorneys or talk to your friends who have used them and what their experience was. Obviously, if you're in Orange County or you're up in the Bay Area, I have a team here and I have a team up there. We would love to help you, but we are not the only ones. I have many wonderful colleagues in the area. We all collectively want to see parents get this done. We're all on the same team. We're on your family's team. So connect with an estate planning attorney and get that done. The second question that people ask is, what about the cost? And so when you go to interview law firms, before you ask them about the cost, I want you to ask them this very important question first. And that question is, what does your service include? And the reason being is not all estate planning law firms are alike. Some are just document mills. People go online for documents, all sorts of stuff. You really need to make sure that you're getting a comprehensive estate plan that truly would protect your kids in an emergency. Otherwise, you are simply paying for a false sense of security. So make sure that you find out those answers of what it costs. I will tell you that at most reputable law firms in Southern California and in the Bay Area in California, that a comprehensive estate plan that kind of addresses all the things we talked about will put you between $4,500 to $6,500, which is a fraction of what probate would cost. And it literally gives you everything that you need, and you can avoid terrible scenarios and you can have that peace of mind. It is worth it. So those are some things that you'll want to look at. One of the things that I want to do to help you is I have a great sheet of, how to interview an estate planning attorney and important questions you can ask so that you can make sure that you're getting everything you need when you are interviewing an estate planning attorney. So in the notes for this video, you can definitely click on that, and we can send that to you. The other thing is I would love to give you a free electronic version of my book, Good Parents Worry, Great Parents Plan. So if in the link, there's if you click on the link, that will send you to a landing page where you can access that book for free and have it. It really covers more in depth the things that I've been talking about in this video. So hopefully that's great to help you get started. And you can always send me a message on Instagram. I'm at Meet the Meiers, and that's spelled Meiers. So you can send me a message through there if there's anything that additional resources you need. And of course, if you are in Orange County or up in the Bay Area, we would love to help you out at the firm. It's Meier Law Firm. Very creative, right, after our last name. But my husband Josh and I own the law firm together here in Newport Beach, and we would be happy to help you. And if we're not the best fit, we can get you with a trusted colleague who can help. And so you can learn more about that at meierfirm.com, MEIERFIRM. Thanks for taking this time out of your day to get this information. Again, I know it's not the most pleasant subject, but it is by far one of the most important. And as parent to parent, we're all on the same team. We hope you have a long, beautiful life, and we want you to live with peace of mind of knowing that you did what you needed to do to take care of your kids. Have a great day.